So in my last video, I talked about the recent UK government consultation on copyright in relation to AI companies using creative content to train their models. And one of the things in the government consultation that is mentioned is that the government is very aware of their international treaty obligations, and it specifically name checks the Berne Convention. Now, since 1886, the Berne Convention has provided for a minimum set of rights that are afforded to creators of works. And all signatories to the Berne Convention agree to include the central proponents of Berne in their own national copyright legislation. And there are some key parts of Berne that I think aren't really being talked about very much at the moment, and yet the current proposals on the table do seem to be completely counter to what is set out in Berne. So I just wanted to sort of maybe explore some of those a bit. So within the Berne Convention, there is what's known as the three-step test. And the three-step test, a bit of a tongue twister, is all about the conditions under which a government can introduce exceptions to their copyright law. So I'm just going to read this bit so I don't mess it up. But essentially, the three-step test says that copyright exceptions should only apply in certain specific cases. They shouldn't conflict with the rights holder's normal exploitation of the work, and they shouldn't unreasonably prejudice the legitimate interests of the rights holder. And I think that when you hear that and you put that in the context of what AI companies are doing in taking creative works and using them to train their models, there's a very strong argument that an exception to copyright law for this purpose would absolutely conflict with the normal exploitation of a work, particularly when you think about the existing licensing schemes that are in operation and licensing agreements between various creative bodies, publishers, etc., and AI licensing companies. So there's a direct conflict there. And that's even before you get into the fact that the outputs of AI generated works are likely to produce competitive products. So again, there's a clear argument there that there's a conflict with the rights holders' legitimate interests and normal exploitation of their work. And Berne also talks about moral rights, and these are various rights that accrue to a copyright holder to give them, again, sort of ownership and control over their work. So it's things like the right to claim authorship, the right to object to any mutilation, defamation, modification, or other derogatory action in relation to their work, and actions that would be prejudicial to the author's honour or reputation. And again, I think if you think about the way that AI can take those creative works and turn them into new outputs, that there is clear risk of authors' reputation being impacted by that. And that's even if the AI outputs recognise the author as the source of the works that are then being created. So there's a lot to unpack there. And I think clearly, the Berne Convention, and particularly around moral rights, are areas that really need some quite detailed exploration by the government in terms of how their proposals really fit in with this. I've still got loads more to say about this consultation, and I think in a future video I'll talk a bit more about the government's proposed opt-out and what that might mean in a very practical sense for those of us working in rights.